Welcome. Welcome to A Taste of Justice with Professor Angela May Kupenda. I'm a professor at Mississippi College School of Law, but I tell you that only for identification purposes. All views expressed here are my own and are not to be ascribed to my students or to my school. Now, in the last video, we talked about qualified immunity, and I gave you a little taste of 3 different stories from 100 years ago, from 50 years ago, and more recently. So what I want to do now is to just summarize some of the principles of qualified immunity. So you will be on the lookout for the discussion of these principles with ongoing litigation you may see and hear about in the news. So first, executive officers receive what is called a qualified immunity. In an earlier clip, we talked about how judges are entitled to a judicial absolute immunity when acting within their jurisdiction, and legislators are entitled to an absolute legislative immunity when engaged in legislative actions. Executive officers, those who are frontline, who enforce the law, or who are acting in an executive role, are only entitled to what's called a qualified immunity. Now, initially, the officers would receive this immunity. It was qualified only if they were acting with both objective, that means a reasonableness type of test, and also subjective good faith, which means they did not have a bad intent. But over time, the court changed that, and it said that an officer could be entitled to qualified immunity even if he had a bad intent. So the subjective requirement was eliminated by the court. The court also held that qualified immunity is immunity from the lawsuit. It's not just immunity from damages, it's immunity from the lawsuit, from having to go to court and being brought into court about a constitutional deprivation. So the court says that if it seems that the officer is going to get immunity anyway, the case needs to end as soon as possible. Now, sometimes plaintiff attorneys are not prepared for this. The government may say, well, let's just assume that the police officer or the executive officer did everything that you're complaining about. Even then, the officer is entitled to immunity. So the plaintiff attorney may not be prepared for that. So it's critical for both sides that there be an understanding just of what qualified immunity entails. Now, since it is immunity from the suit itself, if an officer files a motion to have the complaint dismissed based on qualified immunity, or an officer files a motion for what's called summary judgment before the trial, if it is denied, the officer may be entitled to an immediate appeal just on that point. The way qualified immunity has been shaped by the court, it, in many cases, prevent a trial from taking place on the deprivation or on the violations. Some justices on the US Supreme Court and other courts have said more of these issues need to be decided in a trial and not by a court court, not by a judge on a motion prior to trial. So this case can move rather quickly, which can be very frustrating for some of the parties involved. In determining whether an officer gets qualified immunity or not, the court is going to be looking to see whether the officer has violated a clearly established constitutional right for which a reasonable officer would have known. It is an objective test. It doesn't really matter with immunity if the officer had malice or had bad intent. Now, for some of the constitutional deprivations, that may matter, but just at the point of qualified immunity or not, the court says bad intent is irrelevant, which is another complaint about the qualified immunity defense, at least from the plaintiff's perspective. Now, this point about the law has to be clearly established, a clearly established constitutional right. The plaintiff can't just have a constitutional right. It must be clearly established so that an officer would know that they were violating your rights for sure. I'll give you an example. So in this case called Wilson versus Lane, I give the date of the case and the spelling in the text right below this video. In this case, there was an operation called Operation Gunsmoke. And some federal marshals, what they wanted to do is they wanted to improve how the public saw them. They wanted better public relations. So they invited members of the media to go on ride-alongs. And they took the media into the home when they were looking for a young man. Well, it turns out the house they landed in was the home of his parents, not his home. But the marshals went in with the warrant, searched the house. The father didn't know what was going on. He came running out. He came running out in his underwear. And the mother came running out in her nightgown, and there in the living room were these officers and all of these reporters and camera people taking pictures of everything going on. So the family filed a lawsuit, and they said that their constitutional rights were violated. Now, this is what the court said. The court said, yes, you have a constitutional right. Officers should not bring the media when they are executing a search warrant unless it's related to the execution and unless it's indicated on the warrant. So yes, your constitutional rights were violated, is what the court says, but they say you won't get a recovery. The court said even though their rights were violated, that principle, that right, had not been clearly established in the law before the entry happened. So therefore, the officers were entitled to qualified immunity according to the court, even though a right was violated. But in a future case, if that happens, then that plaintiff may be able to recover. But here there was no recovery, even though a right was violated, because the court said it wasn't really clear to them before they did it that they shouldn't be doing that. Now, the court also says that the right can't be just a general right. Like you may have a general right that you would not be subjected to an unreasonable search. It can't just be a general right. The right must be particularized. Let me give you another example. So there was this officer, and there was this matter going on, and she was seeking to arrest a man for a nonviolent offense. And so at the point when she sought to arrest him, there were lots of people around, there were children who were out. It was a nonviolent offense, but she used deadly force in apprehending him. So he lived, but he was injured, and he brought suit, saying that his constitutional rights were violated by her using deadly force, and it was for his arrest was for a nonviolent offense. Well, the court said that, maybe she shouldn't have used deadly force. The court said her use of deadly force was in a hazy area. It was in a hazy area between acceptable force on one hand and excessive force. It was in the middle somewhere. So the court said in that case, Rousseau is mentioned at the bottom in the text, that she would be entitled to qualified immunity. It gets even more interesting than that. So a plaintiff who was a citizen was arrested not too long after 9/11. And when he was arrested, he wasn't arrested for actually doing something, but it was thought that he may have some information that the government would like to receive in relationship to security in relationship to 9/11. So in getting the warrant for his arrest, there were some inaccuracies stated in order to be able to get the warrant from the judge. So now when he was released, he brought suit, not just an action against the officers, even some of the justices who agreed with this qualified immunity, they said that some of the officers who actually had given him such terrible conditions during his confinement that they might be liable. But he brought suit against the former Attorney General, John Ashcroft. Now the court said, oh, no, he's way up. And this was an evolving thing going on. The court said they had to give John Ashcroft breathing room. And that breathing room may have led to a mistake. But still, they wanted to give him breathing room. So the plaintiff in this case noted that in the text below the video, the plaintiff was denied recovery, and John Ashcroft was given qualified immunity for a supervisory role. Now you may say, give me a case now where the court actually denied qualified immunity. Well, I have one for you. There's some others, but I have one. This case is called Hope versus Pelzer. So it was an Alabama prison, and there was an inmate who had, there had been a problem with his behavior, and they had hitched him up on a hitching post outside for a while, one time. But then another day, he went out with the work crew. He fell asleep on the bus. And then when it was time to get off the bus, he was moving a little bit slow. There was a disagreement between him and the prison guard. So they took him back to the prison, hitched him up on a hitching post. He says they removed his shirt in the Alabama heat in the summer, left him tied there for 7 hours. He said that they did not give him a bathroom break, and they also wouldn't give him any water. And when he wanted water, they gave some water. According to his complaint, they gave water to the dog, and then the guard kicked over the rest of the water. So the question is, are the guards entitled to qualified immunity? Now, this case was kind of, the court had some real difficulty with this one. Ordinarily, with qualified immunity, it's like the court is looking for another case exactly like this one, where the officers should have been put on notice that what they were doing was wrong. And so here, there was some information. Alabama was the only state that still used this hitching post, unless there was some type of riot going on and people had to be secured quickly. And Alabama had been given some warnings that they need to stop using that process. But the guards argued, but there was nothing definite saying we can't do this anymore. But the court said, wait a minute, you knew enough. You knew this was wrong. You knew this was wrong. And in that case, the guards were not given qualified immunity, and the case was allowed to proceed. So in all of these cases, the court is saying that there must be a clearly established constitutional right of which a reasonable officer would know that he was violating your clearly established constitutional rights. And if that's not so, then the officer is entitled to qualified immunity, even if the officer knew better or had bad intent. I mean, look, some of these cases, they may make you feel a bit sad. And as I was reading all of them, I think I got a little sad. I think I became sad too. And it reminded me of something I read a long time ago that W.E.B. Du Bois wrote. And he said, he is in his book, The Souls of Black Folk. I cited at the bottom in the text. And he tells this story about two Johns. One is white, one is Black. They go away and go to school, and then they come home to their small southern town. And the one who is Black has a lot of difficulty adjusting back, of being told to be in his place. And so one day he's having a conversation with his sister. His baby sister notices how sad he seems. And this is what she says to him. She said, John, does it make everyone unhappy? Does learning and studying make you unhappy? And her brother John said, he smiled and said, I guess it does. And then she said, well, are you still glad you studied and learned? And he paused and said, I am. He said it a little slow, but he said, I am glad I learned, even though it has made me feel sad. So his little sister was quiet for a while. Then she says, John, I wish that I was unhappy and sad too. And you know what? I think I am. So I want you to really think about these cases, really think about these concepts. Look back at the earlier clip too. And I want you to join me on this path. We're on a path of seeking more justice, or at least a taste of justice. And I believe a way to get there is by learning. So join me in learning and in seeking a taste of justice, even if it makes you feel a little sad. Thank you, and I'll see you next time.